Our next case deals with the issue of who has the burden to show certain things in the lawsuit. So let's walk through what we've been doing so far and see how the question of burdens tweaks it a little bit. So far, we've been acting like it's always the plaintiff who has to demonstrate something about each element of their claim. So think about Hutchins. It's up to the plaintiff there to show that the husband died, legally at least. It's up to the plaintiff to show that it was an accident. It's up to the plaintiff to show that there was a contract with the life insurance company that obligated the life insurance company to pay out in the event of an accidental death, and so on. So kind of for simplicity's sake, we've been treating it as plaintiff bears the burden of showing stuff, and defendant just has to show that plaintiff can't show what they need to show. That's a lot of shows, sorry. But that is actually not quite right. And the question of burdens asks the question, whose job is it? Because we don't always parse things at a level of generality like we've been talking about so far. We don't always say plaintiff bears the burden of showing something and defendant doesn't. We parse things more finely. Partly that's because we're operating in an adversarial system, and the idea in an adversarial system is that it's the parties that raise the legal arguments and plead the elements of their claims and defenses. So just as a side note, note that there are other ways of organizing legal systems, and in fact, the majority of the world operates in what is called an inquisitorial system, where the judge takes a much more active role in figuring out what kind of evidence is needed and in themselves ordering the production of the evidence that is needed. And in those cases, in that system, you can see the question of burdens taking on a really different role, because it's the judge who needs to establish to their satisfaction what did or did not happen. In our system, however, because it's the parties who are always making arguments and presenting evidence to the judge and the jury, the fact finder and the law finder, we take a particular interest in how the duties associated with those showings are distributed among the adversaries. And, you'll hear me saying this over and over, but it is really important to remember as an attorney that you are the person making the argument for your client. The judge is not going to make an argument for your client. And so whatever you want the narrative to be, whatever arguments you need to be in the record, that is on you to put them in the record. So the idea of burdens, the way we use this word, answers questions like, who needs to raise an issue in order for a court to consider it? Who needs to prove something in order for a court to come to a judgment that favors them? Because again, the court doesn't raise the issues. It's the litigants and the attorneys who do. So there's lots of different types of burdens, but the main kinds are these three. Pleadum, which means raising the issue in your complaint or in your answer. So note that the burden of pleading can be borne by the plaintiff or the defendant, depending on how we allocate the burdens. The burden of production, so providing evidence about something. We've already seen the way that the burden of production is distributed in summary judgment. So in Hutchins, the plaintiff needed to produce evidence showing that the husband's death was accidental. The defendant did not need to produce any evidence at all. They did not have a burden of production. What they needed to do was to be able to say, plaintiff has not produced any evidence that would allow her to meet her burden at trial. And finally, we have the burden of persuasion, which is the burden of making the strongest argument based on the evidence that is produced. Now, one way to think about burdens is that allocating burdens is a way of specifying our default assumptions. So in a normal civil litigation case, Our default assumption is that the defendant is not liable, and it's going to be, in a general way, the plaintiff's burden to overcome that default and show by a preponderance of the evidence that the defendant is liable. But within any case, we can define the elements of the complaint and the defenses that can be offered to that complaint to distribute the burdens in different ways. And that's what you're going to see in Jones v. Bach. So one thing you can be thinking about as you're reading Jones v. Bach is, why does the distribution of burdens matter here? And what does the case look like if the plaintiff bears the burden of pleading versus the defendant bears the burden of pleading the particular issue that they're arguing about in Jones v. Bach, which is exhaustion of administrative remedies. So the need to go through every step of the internal administrative process before you can file a lawsuit in an Article III federal court.